Good afternoon, everyone. I'll ask you to take your seats. We're going to start our panel for this afternoon. For me, it's a really great pleasure to be here today moderating this panel on this so far amazing symposium. We had a terrific day yesterday with incredible panels and speakers, and we hope to maintain the same level of quality today. I hope you all had a good lunch and a good time to rest, and I hope everyone's ready for the last two panels of the day. And for the next 60 minutes, we're going to talk about new developments in alternative dispute resolutions, which is also known as ADR. When we think about ADR, we immediately link to the issue of taking cases away from courts, which can make some judges here a little bit uncomfortable with this idea. But the first thing that I want to say today is, please don't be afraid. I encourage you to think about ADR as a friend and not an enemy. Mediation, binding arbitration, conflict management, and similar non-litigation recourses and resolutions frameworks can make your jobs and lives even better. The second thing that I want to say before we start is that ADR is not only good for judges, but it's also important for lawyers and litigants because it prevents costly and timely lawsuits. We as Brazilians, we know that sometimes it's a little bit cumbersome to solve social conflicts in Brazil via the judicial system, and the ADR is important to solve this kind of issues. And finally, ADR is also good for society as a whole, because ADR can save taxpayers' money on administrative costs and maintain the judicial system. To address this intriguing topic today, we have here two real specialists on the subject who I'm presenting now. First, we have Professor Ana Carolina Riella. She's an outreach and case coordinator for the Harvard Mediation Program, and she can talk more about this because I really didn't know what is an outreach and case coordinator. In 2013, she was selected for the first Harvard Mediation Program Training Corp, a 7-member team charged with teaching new trainees in the program facilitated mediation model. And she also worked at the Boston Law Collaborative with David Hoffman, a Harvard Law School lecturer on law. She also had the position of mediation case coordinator at the Brazilian Immigrant Center in Boston. Anna's legal background includes a position as international associate at Simpson Thacher in New York, in-house counsel at Renault in Paris, France, and also an intern at the International Court of Arbitration at the International Chamber of Commerce in Paris. She received her LLM degree from Georgetown University Law Center and the University of Paris, after earning her JD from PUC in Brazil. Besides Ana, we also have today Professor Tavares. He's a full professor of law at the University of São Paulo. He has served as a professor at the University of Bari and a visiting professor at the University of Bologna, both in Italy. He is also a visiting researcher scholar at Cardozo Law School, New York. He's a former legal advisor to the International Governance and Risk Institute in the United Kingdom. And he's an author of many books, including his constitutional law course book and his textbook on the Brazilian judicial system. Professor Ana, you have the floor.
Thank you. Boa tarde a todos. Eu vou fazer minha palestra em inglês, mas antes eu gostaria de dizer umas coisinhas em português. Primeiramente, eu gostaria de agradecer aos organizadores pelo convite, pelo trabalho duro organizando esse ambicioso e fantástico evento que tem sido até agora. Para mim é um prazer e uma honra estar falando com vocês aqui hoje. E eu espero que essa iniciativa seja a primeira de uma longa tradição de conferências brasileiras aqui na LOSP. Queria cumprimentar o professor André e o Estêvão, obrigada. Eu vou começar fazendo 2 rápidos disclaimers. O primeiro é que, apesar de eu ter nascido e crescido em Curitiba, e os curitibanos ultimamente gostam de dizer que são de Curitiba, eu estou fora do Brasil há 14 anos. Primeiro na França e agora aqui nos Estados Unidos. A minha apresentação vai ser focada na experiência americana de resolução de disputa. Não porque eu acredite, e aí a ressalva que eu queria fazer, que eles... Tá baixo.
Não consegue, a gente ouve na tradução.
Ah, tá bom. Desculpa.
E esse aqui acabou a bateria.
Tá melhor? Tá melhor? Então, como eu estava dizendo, eu estou há 14 anos fora e meu foco hoje vai ser na experiência americana. Não porque eu acredite que eles fizeram ou que eles fazem tudo certo, ou porque eu ache que o Brasil tem que copiar tudo que os Estados Unidos faz. Mas simplesmente porque eu vim dividir um pouco da minha experiência e porque, nessa área específica de resolução alternativa de conflito, os Estados Unidos vêm pensando sobre alguns dessas questões há um pouco mais de tempo que nós no Brasil. Por exemplo, a lei o Uniform Arbitration Act deles é de 1955, revisado em 2000. A Uniform Mediation Act é de 2001. Né? A nossa lei de arbitragem no Brasil é de 96 e a de mediação de 2015. Né? Então, as cortes vêm lidando com isso há mais tempo, os acadêmicos, enfim, existe mais conteúdo aí para o Brasil criar seu próprio caminho e se embasar onde achar que deve, né? Não necessariamente copiar tudo. A segunda questão é que eu não tinha como saber o quão familiar vocês são com esse assunto, né? Então, talvez algum de vocês já tenham treinamento em mediação, já apliquem isso no trabalho, e muito do que eu vou falar hoje vai soar óbvio. Então, peço perdão para esses. Eu não quis aprofundar demais, tentei me manter um pouco no meio do caminho, aprofundar em algumas questões que eu achei mais relevantes e outras nem tanto. Mas, então, vamos lá. We tend to talk about the things we want to learn. And this event has been a wonderful learning opportunity for me. My goal here today is far from giving you all the answers, but instead leave you with questions we can all reflect upon in the hopes that we can reevaluate the way we do things and never cease to improve and modernize them. So here's a brief overview of some of the things I'll be talking about today. First one is the modern ADR development in the United States, so looking back in history a little bit, just to understand where we were and how did we get where we are today. Second, the appropriateness in ADR, and I'll explain, what I'm talking about. The judge as a triage expert, and I don't know if that's a new concept at all. I'm curious to hear from you later on. What do you think about it? I hope it's not too polêmico is the word I'm looking for. Controversial, thank you. And then a word about the Harvard Mediation Program, where I work and what do we do. And then I want to talk about the last point, some of the issues that are being talked about here today in court and in academia that we might or we might not be dealing in Brazil 5-10 years from now, maybe sooner, maybe later. Okay, so the development of modern ADR in the United States. Resolving conflicts outside of the courtroom is nothing new. Humans have done it for centuries, and we can trace it back to the mediations of biblical times, to the maritime arbitrations in ancient Greece. But don't worry, I'm not going to go there. So we'll look at the professionalization of ADR into an industry with its own sets of standards and associations. It began to blossom in the 20th century. If ADR had a big bang in the US, that would surely be the date of the first Pound Conference in 1906. This was the speech delivered by Roscoe Pound, the guy in the picture there,
who at the time, not in this picture, but at the time of the conference, he was 36 years old and later became the dean of Harvard Law School in the 20s and the 30s. He spoke to a group of lawyers, judges, and academics that was the theme of his talk, the causes of popular dissatisfaction with the administration of justice. At this event, Pound criticized aspects of adversarial litigation model. According to records of that evening, the audience was scandalized and some visibly offended that Pound would dare to criticize the profession. So, no substantial policy came out of that event, but it began a conversation of critiquing the justice system. Now, fast forward 70 years, and in 1976, the second Pound Conference, and now you know why it's called that, the Pound Conference, took place to address some of the concerns raised by Pound 70 years earlier. Only this time, the event generated far more specific proposals. It was actually ordered by the Chief Justice at the time, who was Warren Burger. On that occasion, a star emerged among the speakers, and it was Harvard Law professor Frank Sander, who unfortunately passed away just last month. He gave a keynote address introducing the idea of a multi-door courthouse. Sander laid out his vision for a courthouse of the future, which would essentially sort disputes into different categories, something like that. Some that should be litigated and others that should go through other processes such as facilitation, mediation, arbitration, and so on. Instead of sending every civil dispute that came to court to a judge after an extensive discovery process and motion practice, he proposed a new alternative system that could work parallel to the litigation system. This notion of the multi-door courthouse became a hallmark of the dispute resolution movement. Suddenly, courts were no longer merely houses of litigation, but centers where parties might find resources to more fully resolve their conflicts, whether through a court-connected arbitration program, a referral to a nonprofit mediation organization, or an in-house community center. From this notion that disputes should be sorted differently, applying the appropriate forum to the particular conflict, the story of modern ADR explodes forward, with activity rapidly increasing in courthouses, in scholarship, in law school curricula, in legislation, and in practice. Over the course of the past 40 years, Congress has repeatedly acknowledged the benefits of ADR in the US in enacting legislation. I'll comment just a few. There are more. I didn't mean to include everything. So federal legislation, rules of civil procedure, common law jurisprudence, and US Supreme Court precedent. Some of the issues include mandatory arbitration, confidentiality, privileges, enforceability, and good faith participation requirements, among other things. Another important one, so I'm not even going to start commenting on state legislation. As you know, every state has a different legislation. Massachusetts passed its own. And so there's a different ADR law in every state. The Uniform Mediation Act and Uniform Arbitration Act were efforts to create a common state law regulation in different aspects of dispute resolution. So moving on to appropriateness in ADR. Conflict is a growth industry. Anyone knows where that quote comes from? Any idea? Yeah. Getting to yes. Getting to yes. There you go. Published in 1981. This quote, as it say, conflict was a growth industry then, and it is now, and will only keep growing. Why? Because as we bring cultures together and values together and people together, it just doesn't always work out so smoothly and easily. People are interacting more often and at a faster pace, and that creates conflict everywhere. So what to do about it? Find the appropriate forum to resolve each dispute. Or as Frank Sander would say, fit the forum to the fuss. We should stop looking at litigation as the only way to manage conflict. Let's look, for example, at the current Brazilian judicial landscape. I know we're tired of listening to those numbers, but I'd like to briefly mention them one more time so we can put urgency in perspective. According to Conselho Nacional de Justiça, in the year 2016, only 27% of lawsuits were resolved by the first instances, contributing to a tsunami equivalent to almost 80 million pending cases as a backlog. In 2016 alone, 29 million new lawsuits were filed in the courts in Brazil. So now, I'd like to give you only one number from the American judiciary. In federal courts, currently fewer than 3% of all civil cases filed go to trial. That means that the remaining 97% of civil cases are resolved through settlement, dismissal by the court, or voluntary dismissal by the parties. Now, precisely how many of the settlements are due to ADR methods, that we don't know, but it's a larger one. So now talking about mediation, very much like the United States, Brazil is not entirely sold on the idea of mediation. Modern mediation was not easily or readily accepted here in the US, and many would still claim it has a secondary or even tertiary place behind conventional litigation and arbitration. Very much like the US, Brazil is deeply polarized, we all know that, socially and politically. The two countries also share adversarial cultures with a preponderance of litigation and dispute resolution, o que a gente chama de cultura do litígio ou cultura da sentença no Brasil. Unfortunately, that culture does not typically favor amicable, forward-looking, creative, or consensual outcomes. There's still much skepticism or fear on the part of lawyers that ADR could be a conflict of interest that may undercut their litigation business. This is not an uncommon reaction. I want to cite, for example, a famous episode in 2011 when the Italian Bar Association called on its members to strike in opposition to a mandatory mediation law. It takes time to change a culture, but when looking at the Brazilian court backlog statistics, it is clear that we don't have any time to waste in Brazil. I see the issue of courts congestion as a collective problem that requires a collective solution in handling conflict more efficiently. And by collective, I mean lawyers, judges, court staff, public officers, academia, and business community in Brazil. So what do I mean when I talk about appropriateness in dispute resolution? I mean that not every dispute or conflict should be handled the same way, that there is no one-size-fits-all. We're now talking of process pluralism. Much of our choice about what is appropriate depends on who we are having a conflict with. Is it a friend, a family member, a stranger? Is it the government? Is it an organization, a number of parties, a number of organizations or countries? What the dispute is about? Is it a scarce resource like money or property or land? Or is it something else that we could share? Or is it something we want to do that is new rather than routine that we could have a contract for? And what our objectives are that matters too. Is it minimizing costs? Is it speed? Is it privacy? Is it maintaining or improving a relationship? Is it vindication? Is it setting a precedent? Is it maximizing or minimizing recovery? Deciding what dispute resolution process to use is often a complicated choice, and it requires that the legal community understands what each process has to offer. It also requires acknowledging every process has both strengths and flaws. Now, some of you in the room who are judges may be thinking, so what do I have to do with this? This is the parties and their lawyers' choice, right? Not so much, in my opinion. And this leads me to my third point. the judge as a triage expert, looking at it from a new perspective. They call it in the US judicial management, and it started in the 80s. The judge as the manager, as a problem solver, as a triage expert, the one who is in a superior position to determine appropriateness of a case for the courts or another form of dispute resolution and educate the parties about the process, the several types of process. This practice is largely supported by attorneys in the United States. Both the volume and complexity of modern litigation, as well as procedural rules in response to this growth of caseloads, have encouraged judicial management. The role as a triage expert is different than being purely a referee and not getting involved with problem solving. It's about looking at a case and looking at the caseload and advising the parties. Is litigation the best way to go here? Have parties considered other means of dispute resolution? Thousands of hours of trial time and thousands of dollars, and reais in the case of Brazil, of client expense can be saved by these judicial interventions. A central authority needs to take control and help guide the litigation, and the judge is in a superior place to do just that. Of course, that in order to play that role, one needs to be acquainted and comfortable in navigating other forms of dispute resolution. The issue of managerial role is so relevant and so timely that the Association of American Law Schools section on ADR announced the winner of Best Article Published, and this was just last week. Best Article Published last year, and the theme of the chosen article was precisely what we're talking about, beyond managerial judges, appropriate roles in settlement. Now, here is a list of some potential questions a judge might ask to help parties consider the use of alternative dispute resolution. Of course, these are only a few examples, and the managerial role and triage expert goes way beyond asking those questions. This is just so you can start thinking about those issues. So would it be helpful if I read it? Not so much, maybe not. I'll read just a few. Have the parties considered using alternative dispute resolution? If the parties have decided against ADR, what has led them to that decision? If some issues are not appropriate for ADR, might some of the other issues be appropriate? So can we consider maybe bifurcating a case, send some issues to mediation and have trial on some other aspects of the issue? Have the parties already tried to settle the case? Are any rulings needed before an ADR process can be productive? Is there certain information that, if exchanged promptly, would make an early ADR process more productive? And have the attorneys spelled out for their clients the potential costs and time commitments of litigating the case? So that in the US, actually, the attorney has a duty, an ethical duty to advise his clients on ADR. And I believe that in Brazil, we don't. It's something, in my opinion, we needed to change. So a word about the Harvard Mediation Program and mediation and what we do and some of the new developments within the program. So the program was established here at law school in 1981. It's part of the Harvard Negotiation and Mediation Clinical Program, and it has both an educational and a service mission. We strive to provide students and community members with comprehensive and ongoing training in the theory and skills needed for effective mediation. We provide opportunities to apply those skills in real-life mediations and to provide a service to the courts and to the community. From July 2016 to June 2017, we have mediated 186 cases, both inside and outside of the courts. For those of you who are not so familiar with what mediation is, I'd like to play a short video we recently made trying to give you an overview of the mediation process. Keep in mind that this is a process that can take anywhere from 2 to 3, sometimes more hours, sometimes several sessions, and we try to make a 4-minute video. So this is a very brief overview, but it'll give you an idea.
Mediation is a voluntary form of dispute resolution that helps parties in conflict reach their own mutually acceptable solutions. This video provides a brief overview of the stages of a typical mediation. The Harvard Mediation Program uses a co-mediation model in which 2 mediators work together as a team. Hi, I'm Christina.
Hi, I'm Pratik. Can we get your name?
I'm Ethan.
My name is Olivia Jones.
Are you comfortable using first names today?
Yes.
We'd like to go over a few key points about mediation. It's voluntary, confidential, and we as mediators are neutral.
And let's take a minute to go over each of those points. So starting with voluntary. We'd also like to review the process that we'll use here today. We'll start by meeting together and hearing from each of you.
Then we usually check in with each other, and we may decide to meet with each of you separately. We'd like to hear from each of you now. We'll start with Ethan, since he brought the claim. Tell us a bit about what brought you here today and what might help you resolve the dispute.
Well, it all started a couple months ago. I'm a contractor. I do general construction, that sort of work. So I won at least $3,000.
And why is that important to you?
I think it's a fair estimate of the work that's already been done.
Could have paid you, but you could have asked me. I mean, I think it's really unfair
you
that
fired
I
me. You
hauled
fired
into
me over
court
a
like
voicemail.
criminal.
The parties seem pretty heated.
Yes. What do you think our next step should be?
Well, let's meet with Olivia first.
Thanks for your patience. This private session is an opportunity for you to discuss with us anything you might not want to say in front of the other party. Is there anything you'd like to share with us privately?
It's not fair that I'm here, that I got hauled into court because of a communication error.
Thanks for your patience. This private session is an opportunity for you to discuss with us anything you might not want to say in front of the other party. Is there anything you'd like to share with us privately?
You know, I can understand that it's taken longer than I expected.
We just met with each of you privately. We seem to be making progress and discussed a number of options with each of you.
Would you like to share with each other any of those options?
I think it would be fair if you paid $3,000. What do you think about that?
Well, I'm willing to pay something, but I don't think that amount is fair, and what I really want to talk about is the fact that you never returned my calls. The only thing preventing this from being resolved is that he didn't call me back after I left messages, and I just think that's really shoddy business practice. Well, I'm glad we discussed these options.
I agree.
So it sounds like you've agreed that Olivia will pay Ethan $5,000 once the work is complete. Is that right?
Yes.
Sounds good to me.
Great. We'll help you write that up.
So I'm just going to read out loud your agreement. We have taken part in a mediation session on March 27, 2018, and have agreed to the following terms and conditions. Ethan will finish the porch in the next 4 weeks. Olivia will pay the remaining $5,000 upon completion of the work, and Ethan will return all calls within a business day. The agreement was entered into voluntarily and in good faith. This agreement, when complied with, settles all claims relating to case 34521. Have we recorded the terms of your agreement correctly?
Yeah.
Yes.
Great. Please read and sign the agreement.
I'm glad we were able to work this out.
Yeah, me too. Sounds like a deal.
The Harvard Mediation Program conducts surveys after completed mediations, and more than 90% of participants were satisfied with the process, regardless of whether their case settled. Mediation with HMP offers the benefit of a process that is unbiased, efficient, and empowering to the participants, who have an opportunity to be heard and to make their own decisions about whether a negotiated resolution is the right one for them.
Okay, thank you. Well, it doesn't always end like that, but sometimes it does. Okay, yeah, so a few of our latest developments. one of the things we try is to diversify the types of cases that we mediate. There's so much opportunity beyond the very appropriate divorce and commercial cases, which are the typical situations where mediation process is used. So we don't mediate divorce cases, by the way, but it's a very appropriate situation for mediation. We do mediate several other types of cases. 3 new kinds of cases that we've been mediated since recently. First one is HPO cases, which stand for Harassment Prevention Orders. And this is a court order to protect a person from harassment and abuse by someone else who has harassed them. They can be filed against anyone. In order to get an HPO, a person must show that the defendant has harassed them, which means 3 or more acts of willful and malicious conduct aiming at a person and committed with the intent to cause fear, intimidation, abuse, or damage to property. I try to find an analogy in Brazil, and I think this would be similar to a medida protetiva, maybe, only that in this kind of HPO that we mediate, there is no violence or sexual abuse involved. And by the way, we don't mediate cases that involve violence, nor do we think that these cases are appropriate for mediation. Then you have juvenile HPO cases, which are similar to the cases I just explained, only that the parties are under 18 years old. A common and growing kind of case is harassment on social media. The third kind of case is complaints filed by civilians against police officers. And we mediate between the police officer and the person who brought the complaint. So these are some of our latest additions, other than the cases we typically mediate in the courts and outside of the courts. So my last point is going to be about issues debated in the United States that might be potential questions for Brazil later on. First one, confidentiality in mediation. So will Brazilian courts uphold the principle that memoranda, files, and work product prepared by the mediator are confidential and not subject to disclosure in a court proceeding? Will courts uphold the notion that any communication made in the course of a mediation is confidential and mediators cannot be forced to testify? The support of the courts could go both ways, might encourage or kill other processes. If a mediator is forced to testify in court, for example, think about what's the effect it has on other people considering mediation, to whom confidentiality matters. So we shall see if the courts will back us up. Second one, the enforcement of mediation agreements. An agreement reached in mediation is as binding and enforceable as any other agreement as long as it is in writing, conforms to the doctrines of contract, including being free from fraud or coercion, and does not oppose public policy. Will Brazilian courts guarantee enforcement of mediated agreements whenever necessary? We shall see. Another new development in that regard, enforcement, is that UNCITRAL, the United Nations Commission on International Trade Law, is working on a treaty for the enforceability of settlement agreements reached through international commercial mediation, just like the New York Convention of '56 on the recognition and enforcement of foreign arbitral awards. Although this is an exciting development, it may take a long time to get ratified and to get the same acceptance that the New York Convention does. Third point would be, as I mentioned earlier, the duty of counsel to discuss ADR with client. In the US, if a lawsuit is contemplated, an attorney has a duty to advise the client about ADR prior to filing the lawsuit. That's in the Rule 5 of the Supreme Judicial Court Uniform Rules of Dispute Resolution. So, like I said before, o Código de Ética e Disciplina da OAB, for instance, should it include a provision in that regard, or should such provision be included somewhere else? We need to talk more about the role of counsel in ADR proceedings. There is still a number of litigators and clients who are concerned that any suggestion of ADR or settlement is a sign of weakness and or fear of going to trial, and we need to change that too. Another one is, Oops. The judge who should the judge who mediates a dispute also be the trial judge? Will they remain impartial? In the US, ethical limits have been left to judge and counsel. The judge may disqualify himself and pass the case along to a colleague if he or she felt their settlement efforts raised an issue of impartiality. So the judge, during mediation, found out something that he thinks, if the case goes to trial, will interfere in his ability to decide. Also, one of the attorneys could seek disqualification of the judge. Is atmosphere of fairness and neutrality really fostered? Are judges sufficiently trained in formal ADR to do that? There are arguments on both sides. One side, for example, argues that there is too much of a partiality risk if the judge is both the ADR person and the trial judge. What happens to the party who does not agree to settlement proposals and wants to stand their ground? Is there enough training in ADR techniques for judges and court staff? The other side sustains that, yes, the judge could play both roles if, one, there's party consent, two, as long as the judge discloses their settlement techniques to parties and attorneys, and three, as long as judges receive mediation training. It would be okay for the judge to do that. Another thing is affirmative efforts to convince the state to use mediation. We know that in Brazil, the state is the biggest litigants in Brazilian courts, and who does not make use of ADR proceedings very often. We should be talking about that too. And final point, quality control of ADR programs should also be discussed. How should we measure in the future the effectiveness and quality of ADR programs? Should it be by the number of settlements? Should it be by the satisfaction of the parties? Should it be reduction of court backlog? So this is also a big debate, and no system is perfect. But of course, quality control should be there. And I'll conclude with a quote and a story I want to tell you about. So this is a quote from Abraham Lincoln, who said, "Discourage litigation, persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often a real loser in fees, expenses, and waste of time. As a peacemaker, the lawyer and the judge has a superior opportunity of being a good man. There will always be business enough." I must confess that I was the one who added the word judge in there. So to conclude, a quick story about dispute resolution. It made so some of you will have heard about it. Actually, how many of you have heard the story before? Yeah, it's traditional. It's a classic one in dispute resolution. Also oversimplistic, but I think it gives you, it's a quick way to convey what mediation does. Okay, so the story goes like this. Two people are fighting over an orange, and there's only one orange. You can't get any orange anywhere else. So you come in and you try to resolve that dispute. What would you do? The people who know the story, please don't say anything. What would you do? Any ideas? What would be the fairest way to resolve the dispute? Split the orange, right? Give each party half. They'll go out with 50% of what they want. Everyone's happy. Fair enough. Well, Bob Dylan's son, who sings at a band called the Wallflowers, he sings, "There's got to be something better than in the middle." And so a mediator comes in back to the story, and asks the parties a simple question: why do you want that orange? One of the parties responds, well, I have a cold and I need vitamin C, I want to drink the juice. The other party says, it's my son's birthday, I want to bake a cake for him. I want the rind to bake the cake. So there you go, with a simple question. One party gets the juice, the other gets the rind. Everyone leaves with 100% of what they want. Again, it's very simple, but it's a way of trying to convey to you what mediation is trying to do. So to conclude, my call to action here today is for all of you to get acquainted and trained, not necessarily to become a mediator, but to be comfortable with these different types of processes so you can educate parties about them, embrace the role of the judge as this triage expert that is so needed, as a problem solver. And Ministro Barroso yesterday, he quoted the Italian poet saying that there's crisis because the old is dying and the new is not yet born. So I think that if you look closely, in some cases, the new is already there. We just have to embrace it. Thank you.
Thank you for this wonderful presentation. And before we continue, I just want to say something. We have this app and this website here, slide.do, where you can ask questions. And we're going to answer the questions in Portuguese. And you can also ask questions in Portuguese. Professor André Ramos, you have the floor.
Thank you. I'm also going to talk in English. So, first of all, I would like to thank Harvard Law Brazilian Association for giving me the opportunity to be part of this panel at this legal symposium and present some points of my research about the judiciary, about the ADR, and about the cultural problems in Brazil. I would like to congratulate also Professor Ana Carolina Riella and to salute the moderator, Estêvão Gomes. I also congratulate all those who have helped make this event possible. The Brazilian judiciary is haunted with a culture of litigation and delay. So, alternative dispute resolution, here after ADR, right, plays an essential role in Brazil. That's my research on ADR. That's why my research in ADR is related to the judiciary system. It doesn't mean, of course, that I propose or even that I assume judges as pivotal elements in ADR. I will then formulate an overview to explain why ADR in Brazil is a new phenomenon that still depends on some laws. In this scenario, it's also important to know if the judiciary is seen by the citizen as the forum of last resort or if the judiciary is seen as the forum of the first resort by the citizens. Brazilian culture is characterized by the supremacy of courts to deliver solutions to all social conflicts, above all other ways and methods. So for me, ADR also depends on the relationship between state and the population. I will also present some innovative solutions with new technologies adopted in Brazil. Not surprisingly, those new solutions came from the state. So, what are the premises of the Brazilian context? Does the judiciary reinforce injustice and inequality in Brazil? Brazil has colossal numbers. It's the case of population, territory, and natural resources, as we know. But it's also the case of underdevelopment, social, economic, and educational underdevelopment. Unfortunately, the judiciary branch has become part of this dilemma And we will see some figures that indicate a huge problem, as Professor Ana also told us. The main problem here is that judiciary reinforces inequality and injustice. There is a shocking affirmation, and that's the reason why ADR is related to the judicial crisis in Brazil. I'm not talking here, of course, about the content of the decisions, but I'm talking now about numbers. The most common criticism is that the judiciary is sluggish. For our issue, it's important to point out that one of the main causes is precisely the culture of litigation that bring all aspects of life into the judicial sphere. The Justice in Figures report of 2016, presented in 2017 by the National Council of Justice, CNJ, pointed out that there are nearly 9.7 million cases for a population of 207 million people. If the judiciary stops receiving new cases now, it would take almost 3 years to handle all the cases that the judiciary already have. It's interesting. Rafael Bielsa, a well-known Argentine lawyer, author, and politician, elaborated in 1994 a judicial report for the Argentine government. It talked about the collapse of the judiciary. And we should note that the Argentina at that time had less than 2% of the lawsuits Brazil currently has. Those figures in Brazil also reveal two more things. First, there is a continuous increase of lawsuits and continuous backlog. Second, backlogged cases are concentrated in first-level judges and in small claims courts. The escalating phenomena of judicial litigation in Brazilian judiciary indicates the need for adequate policies and strategies such as the improvement of ADR, also referred to as adequate dispute resolutions. But why? Because the so-called Fordist paradigm, according to which we should increase the number of judges, civil servants, and physical structure if the number of lawsuits increases, is no longer an alternative in Brazil. We already have 90 superior courts, like, tribunal, accounting here, justice courts, tribunais de justiça, the states courts, the federal courts, labor courts, military courts. We have 90 courts, each one with a lot of buildings. For example, in São Paulo, we have 850 buildings only in one of these courts. Only Tribunal de Justiça, only in the Justice Court of São Paulo, has 850 buildings. The state justice in São Paulo has almost 50,000 civil servants. And the budget of this court, not involving the other courts of São Paulo, only this court has a budget that is bigger than 8 states of the Brazilian Federation. I know that ADR usually is conceived as the best solution depending on each problem presented, not as a solution for a judiciary macro crisis. But in Brazil, it should be considered as part of the judiciary solution. I will try to explain it briefly. It occurs because the possibility of ADR in Brazil was blocked by many laws. That was the case of recent laws that freed judiciary from being a formal stage for some conflicts and allowed people to have an extrajudicial solution. So ADR in Brazil partially depends on an action from the Brazilian parliament. It's also the case of it's also the case of litigation culture, where ADR is also a solution for a judicial problem and strives to reintroduce equilibrium among all possible solutions. The delay fosters a dysfunctional system because it stimulates the non-fulfillment of obligations. So let's talk about this explosion of numbers. Is it correct to say that the population in Brazil, prefers solutions achieved or intermediated by the judiciary? One important question here is to know if the judiciary is seen by the citizen, as I said before, if the judiciary is seen by the citizen as the forum of last resort, or if it's seen as the forum of first resort. That's an important question to understand the Brazilian context and also to understand why ADR is still an important issue to judiciary in Brazil. Brazil is one of the most unequal countries in the world, and one can notice that and can notice the difference between the behavior of the citizens. The Brazilian judiciary is perceived as less accessible to the most underprivileged. Last year, 1.5 million Brazilians shift from poverty to extreme poverty. This data was released last week from the Brazilian National Household Sample Survey conducted by the Brazilian Institute of Geography and Statistics. One of the main problems of access is excessive formality and the complexity of Brazilian laws and judicial processes. Despite the existence of legal aid from the state institutions, like the Public Defender's Office, and despite the existence of legal aid from free private from law schools, the underprivileged suffer an aversion to resolve disputes through the judiciary. This is important to understand in which way ADR could be developed and stimulated in Brazil. It also reveals that ADR is not only about reducing judiciary volume. The official Brazilian National Household Survey in 2009, that was the last one, was also dedicated to measure the access to justice. It was very interesting. It revealed that the low-income population seeks solutions to their conflicts mainly outside state and judicial institutions. This segment of the population prefers solutions achieved or intermediated by friends, relatives, or by the church. And we have to remember that in Brazil we have 172 million Catholics baptized. It's the first in the world, according to the Vatican. But the underprivileged, the low-income population, accept judiciary in conflicts mostly related to family disputes, health insurance, and social security. Higher income people usually go to the judiciary to demand consumer, labor, and land rights. So we can say that judiciary is the forum of last resort for the underprivileged people and the first resort for the rest. It's also the first resort for companies, as we will see. The National Council of Justice in 2012 identified the main parties in Brazilian lawsuits. As Professor Ana Carolina already said that. Let's list, this list is as follows. First, it's the union. Second, the banks. Third, the cities. Fourth, are the states of the Brazilian Federation. And fifth, we have the telephone companies. Those institutions and companies got more efficient in their lawsuits than sporadic litigants, than the rest of the population. And this has led to an unbalanced judicial process. This advantage also stimulates the aforementioned litigants to block ADR. There is another aspect. In the new Brazilian democracy, as Justice Barroso said yesterday, the stability of the currency and the greater social inclusion that we really have had in the last years has led us to an explosion of consumption. This new scenario brought new and more demands into the courts because of bad service and products offered by a large number of companies. It's important to note that Brazil has a very high level of consumer protection. Professor Pendy talked about laws on the paper yesterday, and it occurs in Brazil. Nevertheless, it's used to access judiciary. It's also important to review some of the data on how companies and state have concentrated a large number of lawsuits in Brazil. Large companies, such as banks, communication companies, especially internet providers, cable television and telephone companies, and other private providers of public services like energy, water, and sanitation, prefer to deal with the lawsuits of the few unsatisfied consumers than improving the services or products they offer. Companies do the math and see that defending themselves from the individual lawsuits of a few clients is cheaper in Brazil than restructuring their companies in a way to provide better quality products or services. Companies still see the judiciary as the first resort to deal with their conflicts, especially as defendants. Luiz Felipe Salomão, as you know, a justice from the Superior Court of Justice in Brazil, he said that he believes, that's very interesting, he believes that companies try to transform the judiciary branch into their call centers to make their business costs cheaper. It's an utilitarian option, of course. This is the kind of operation done by many companies. This means a permanent violation of consumer rights, aiming to improve financial outcomes. It also offers a perfect scenario for ADR, but it needs some aid from changes in culture and law. The problem of litigation is also in Brazil educational. It's educational. Research published in 2010 examined the 31 biggest law schools in Brazil, and concluded that 53% didn't offer any class related to arbitration, mediation, or conciliation. Nothing. 26.9% offered classes related to those topics as elective courses, and only 19.2% as mandatory classes. The culture of conflict is a perverted conception of law created in Brazil, mainly in the judicial area, and tries to justify all social conflicts in the judiciary. The right to access needs to move away from being exclusively to courts and needs to improve to a right to access the law beyond the judicial sphere. ADR is essential to reduce pressure on the Brazilian judiciary. Laws have been approved and have led us to less dependence on the judiciary. For example, Law number 10.931 from 2004 allowed an alteration of lands registers without the interference of the judiciary, something that was forbidden before. The same occurred with divorce. Those legislative solutions fortify the case for ADR. Although useful, they are not the solution. And in Brazil, we also have to talk about the fees as an obstacle to ADR. The court fees payable by the parties are charged at the conclusion of the proceedings. Unsurprisingly, it incentivizes once more the culture of litigation and creates natural objection to ADRs. Fees may not only be used to assist finances of the courts, but may be used to open field to negotiation. So fees should be a deterrent to using the court unnecessarily. That's the damage access justice. Fees force an agreement or negotiation between litigants. A new law in labor justice has settled fees on the basis of full cost recovery for the prevailing party in the case of moral damage suits. It's a new law. The headline of one of the main newspapers of Brazil, o Estado de São Paulo, in April 1st of 2018, April 1st, but it was real, the headline said, "New labor law reduces the lawsuit industry." It was the law number 13.467. When litigants use the court as the forum of first and only resort, many thousand cases presented to the court each year could easily be resolved by other means. It's also clear that the banks in Brazil take court action to recover debts without making any effort to do so by other means. The probable case is because this is the option that has the lowest cost, as I said before. Some conflicts are not adequate to be resolved by the judiciary. So, talking again about banks, creditors should make more efforts to contact the debtor and discuss a repayment plan. There are generally much quicker and less costly options. We have ombudsman service, trade associations, and mediation services, mediation centers. The rules in England and Wales, for example, now require the creditor to pursue other avenues before commencing proceedings in the court. It's the same in Germany and in Denmark, where there must be proof of an attempt at a negotiation before going to judicial process. And Professor Ana also was talking about this in the United States. In a decision from 2002 of the British Supreme Court of Judicature, the discharge of the parties' duty to consider seriously the possibility of ADR procedures was relevant to the question of costs. According to the court, and I'm quoting now, it's to be hoped that any publicity given to this part of the judgment of the court will draw the attention of the lawyers to their duties, in the way that if they turn down out of hand the chance of alternative dispute resolution when suggesting by the court, as happened on this occasion, they may have to face uncomfortable costs consequence. End of quote. When creditors pay merely one fee at the commencement until the final judgment, if it creates an incentive to not even attempt to settle the dispute out of the judiciary. This is still the case in Brazil. As part of the civil justice reforms during the late 90s in the United Kingdom, for example, the decision was made to introduce a range of fees that reflected and compensated the court for the resources being used by the court. The paradox here is that ADR is criticized because supposedly it does not remedy the economic disadvantage of one litigant, especially in consumer and banks case. And this is a critical issue given the inequality in Brazil. But on the other hand, ADR fits conflicts that are not usually carried to judiciary. It also fits conflicts for people seeking low costs. Here we have, again, an utilitarian choice for ADR that has always been in perspective, because it's an informal environment with simplified language. The paradox disappears, the paradox I told about, disappears if we don't see ADR as a substitute for the educational system. So, what are the conciliation and mediation solutions in Brazilian law? Actually, we have various new paths created by law and by the judiciary in Brazil. Of course, In those cases, people perceive it as a socially sanctioned decision-making process, as Nancy Welsh calls it. But the law was necessary to take away the suspicion that ADR had suffered in Brazil. Although the roots of ADR date back to the 60s and 70s and much more in the United States, Brazil had a proliferation of these methods, especially since the 90s. In 1995, law number 9.099 required conciliation before the initial judgment of lawsuits. Since 1994, it has been a duty of the judge to attempt conciliation before beginning the judicial process. And also remember that I served as volunteer, as conciliator at that same year in 1994. Conciliators and mediators must be registered by the court, and each year a ranking is formulated by each court, a rank of conciliators, mediators, and private centers of conciliation and mediation according to the success of each one. There is also a very important national conciliation policy established by the National Council of Justice from 2007 in Brazil. Also, we have the law number 13.140 of 2015 that allows mediation with no judicial process, of course. In reality, a prior attempt at agreement before judicial actions is always more efficient and also keeps the judiciary structure for adequate cases. In São Paulo, the Conciliation Department of Justice announced that until 2007, negotiation in judicial process had 22% of success in São Paulo. 22% of success, against 76% of success in case of non-judicial contact. The new Civil Procedure Code of 2016, as you know, foresees conciliation and mediation as part of an obligation for litigators. Indeed, it doesn't have numerous clauses of ADR methods. All courts have created a conciliation center. It's now an obligation of all lawyers, judges, and prosecutors to stimulate ADR, including during the judicial process. I believe the same occurred here in the United States. But in Brazil, it's clearly prescribed as a solution for a judiciary crisis. It's now an obligation to have a specific hearing at the beginning of a judicial process to try the conciliation or mediation. However, it's not advisable that judges act as conciliators or mediators, because judges are used to an adjudication process and are used to an authoritative attitude. If the parts reach an agreement, the judge must homologate it and the decision becomes an enforceable judgment. This provision is in Article 334 in the new Civil Procedure Code. But after the new imposition of the new code of 2016, the numbers in 2017 showed no improvement. No improvement. We had 30.7 million decisions in Brazil and only 11.9% of agreements, which must consider a very low rate, almost the same as the previous year before the code. But in this scenario, labor courts have done better and made more conciliations than others. We created also the annual National Week of Conciliation, and this is a week. It's very important. In 2017, there were almost 320,000 hearings all over the country in 1 week. And in that week, we got more than 225,000 agreements. 7% of success. 70. It's, of course, a solution that depends on the state structure. As Oscar Chase warned, talking about the United States, these non-judicial conflict solutions had become part of the official mechanism to pacify, not only because they are integrated into the judiciary structure, but also because they were certified by law. Otherwise, and I'm quoting now, the goal of an ADR program that is sponsored by a public court cannot be simply to have the dispute over. And now, and I'm ending, let's look at the influence new technologies have had on ADR in Brazil related to the judiciary. We now have online dispute resolutions, ODR. It's considered by many an electronic version of the same non-judicial conflict resolution means. Usually, it uses its own electronic platforms to bring about a meeting between the parties in chat rooms. In my opinion, online dispute resolution should not be considered a mere substitution of the traditional forms of communication and meetings. This should be an underdeveloped use of technology. We should consider an ODR only if it offers a different environment with different tools than the traditional extrajudicial mechanisms. ODR would be a new door next to the non-judicial door in a realm of multi-door justice. And this is one of the services offered by some of the legal startups in Brazil, and also by the National Council of Justice, as we will see. In the 13th edition of Innovare Award, one of the honored projects was the use of WhatsApp for the conciliation and mediation hearings in the labor justice of Campinas. In the project, a civil servant acts as mediator and administrator of the group. The negotiation is ratified live or by video, and then it's sent to the judge for homologation. All conversations are transferred to a digital process. The 97 groups created in 1 year had a rate of 75% of success, and agreements reached $1,600,000. We also have some, as I said, some legal startups that deal with electronic platforms to facilitate mediation. And those startups consider this kind of alternative 6 times cheaper than the judiciary. Recently, the National Council of Justice launched a digital mediation platform to foster this type of alternative dispute resolution all over the country. The system allows agreements to be concluded in virtual form among parties of lawsuits that are physically distant, such as consumer and businesses. And one of the most interesting solutions in Brazil is the mobile court, adapted in vehicles, buses, vans, and boats, moving to remote areas of Brazil, carrying teams of judges, prosecutors, civil servants, defenders, and also conciliators. It's called Itinerant Justice, as you know, and started in 1996 in the State Court of Amapá in the north of Brazil. In 2004, Itinerant Justice became mandatory with the 45th Constitution Amendment, determining that all courts in the country should create them. Although its costs are still supported by the public money, it seems to be a necessary measure in a country like Brazil, so vast but still very underdeveloped in some areas. It's a public path to increase conciliation in some remote areas. Research done in 2015 by the Institute for Applied Economic Research, IPEA, showed that all states generally have or have had at least one itinerant court service. However, there is a wide variation in types and in the form of operation of the various projects. So we should expect a cultural shift in society and also in the next generation of lawyers with all those changes in Brazil. ADR is culture. As I said, it also depends on the relationship between government, state, and the population. People should know, and lawyers must advise that mediation and conciliation are, in some cases, best ways to solve the problems, and going to the courts should be avoided. The judicial process, indeed, should be the last resort for most people to solve their problems. Thank you all.
Thank you, professor. A gente vai responder perguntas agora em português, como combinado. São duas... vou fazer uma questão para a professora Ana Riella e uma para o professor André Ramos Tavares, considerando o nosso tema. Para a professora Ana Riella, uma pergunta da audiência. Existe uma questão aqui relacionada a honorários advocatícios. O professor André Ramos Tavares falou um pouco sobre isso na apresentação dele. E a pergunta, ela questiona se os honorários advocatícios eles funcionam como um economic deterrent, um incentivo negativo, né, para a implantação de ADR no Brasil. O que você pensa sobre isso e qual a sua opinião sobre essa questão?
Então, a questão do honorários dos advocatícios, eu acho que, como eu falei, alguns sempre vão ver isso, alguns advogados sempre vão ver isso como um conflito de interesse, não só no Brasil, como no mundo inteiro. Eu dei o exemplo que eu acho que é emblemático o suficiente do que aconteceu na Itália em 2011, onde o equivalente ao OAB da Itália chamou uma greve em resposta a uma lei de mediação obrigatória. Minha opinião é que o advogado preparado hoje vai saber e vai entender que uma disputa resolvida de maneira eficaz e rápida vai fidelizar um cliente. Vai fazer com que o cliente volte e traga outras disputas. Enfim, eu acho que volta a questão do appropriateness, né? Ele vai ganhar os honorários advocatícios também defendendo o cliente em mediação. Defendo que o cliente vá sempre acompanhado, que a parte não seja pro se em mediação, como muita gente acha que tem que ser, e que o advogado tem que ter tá ciente que ele tem que ter uma postura completamente diferente numa mediação do que ele teria num tribunal, coisa que a gente não vê hoje, né? Advogados entrando em mediação achando que estão lá com comportamento de Rambo. Enfim, então acho que não vejo isso como um deterrent, entendo que sempre haverá e estou aí defendendo que isso tem que mudar, né?
Vou entrar na discussão. O que acontece? Eu concordo com você, eu acho que é exatamente isso. E eu acho que o exemplo melhor é aqui dos Estados Unidos, né? Se eu não me engano, os últimos dados provam que cerca de 95% a 98% dos casos aqui nos Estados Unidos terminam em acordo. E a gente estava discutindo antes de começar o painel que o mercado jurídico dos Estados Unidos é completamente diferente do brasileiro e os advogados são muito bem remunerados aqui. Então, o fato de existir outras soluções de mediação, elas não impedem que os advogados sejam bem-sucedidos, sejam muito bem remunerados. Eu acho que as questões são um pouco mais complexas do que isso. Obrigado pela resposta.
Obrigada.
Para o professor André Ramos Tavares, a pergunta da audiência, a pergunta mais votada, inclusive, o que o senhor pensa sobre o uso de tribunais administrativos independentes para a resolução de disputas contra o governo, como ocorre na Common Law?
Eu sou favorável também. Até essa é uma discussão um pouco longa, né, porque envolve questões que muitas vezes dependem de que uma lei libere, né, a possibilidade de que haja esse tipo de negociação envolvendo Estado, né? Acho que é nesse sentido a pergunta. Mas me parece que seria também apropriado nós expandirmos para esse setor esse tipo de termos essa alternativa. Eu também me lembro, recentemente participei de uma banca na PUC de São Paulo, foi do que hoje ele é o ministro Reinaldo, e ele justamente teve um trabalho ali que ele propunha exatamente isso, né, que a gente examinando um dos aspectos. O ministro Reinaldo Fonseca então dizia que ele é também um especialista nessa área, dizia que nós deveríamos também tentar caminhar para nesse sentido. E de uma maneira geral, eu acho que nós precisamos ser ainda mais criativos no Brasil. Acho que nós precisamos criar outros mecanismos, até outros centros, pré-centros de conciliação. Não é? Há uma grande parte da população que eu tentei trazer aqui, que é uma grande parte da população que não vai ao judiciário. Nós estamos vendo números assustadores relacionados ao Poder Judiciário brasileiro, e a culpa não é do Poder Judiciário brasileiro, obviamente. E isso se torna ainda mais assustador quando a gente percebe que, segundo a última pesquisa feita, a maior parte da população pobre não leva os seus litígios ao Poder Judiciário, né? Então, aí nós temos aí uma grande dificuldade para superar. Isso significa muitas coisas. Significa também que essa população pobre não tem acesso ao direito, né? Não estamos falando de acesso só ao judiciário, não tem acesso ao direito. Então, pode ser por diversos motivos, né? Inclusive alguns eu mencionei, pode ser por outros motivos, pode ser por até falta de conhecimento, né? Como dizia o Capelletti, o Brian Garth, quer dizer, falta de próprio conhecimento dos seus próprios direitos, ou mesmo porque considera que o mecanismo estatal é extremamente complexo e eles preferem evitar esse tipo de alternativa, né? Então, eu acredito que sim, a resposta é sim. Enfim, acabei falando de outros assuntos, mas eu concordaria com essa expansão, sim.
Obrigado pela resposta. Em nome da Adr Law School Brazilian Studies Association, a gente agradece aqui a presença do professor André Ramos Tavares, da professora Ana Riella, e eu queria que você se juntasse a mim no aplauso aos palestrantes.